Alrighty, second video. Something I'm going to do, if not on a regular basis, I'm going to do this on at least an infrequent basis. Maybe every video, I don't know. Riddle me this, Batman. Alright, now that's part one of an IQ test called Raven's Progressive Matrices. And that should take you no more than, let's say, 5 to 10 seconds to solve that. If it's taken you a minute or two to solve that, yeah, you may not want to consider voting. Alright, the last video was about how we lose our liberty through contract. And I'm going to give you a concrete example of that. It doesn't do you any good to complain about something in the world if you don't have solutions. And the whole purpose of this channel is to provide people that fall within that gambit, within that scope, the ability to frame arguments, do research, and to be able to effectively defend themselves through the different topics as we go through them. All right. You lose your liberty through contract. Well, let me give you a case out of Douglas County, Colorado. It's unincorporated, so it's not Castle Rock directly. I'll just give you a synopsis of the case because it's boring, but for those people who need it, it's informative. All right, so it's a zoning issue. I actually touched on that on the first video. The county went after this couple because they put up a fence in their front yard. They had some construction going on because of water damage in the property, and they put in some 20-foot containers to be able to put all of their stuff in while the general contractors were working on the house. All right, that seems innocuous, right? Well, then the county sued them for putting up the fence and erecting structures on the property, notwithstanding the fact that there's no definition anywhere as to what constitutes a fence. Statutes or local ordinances, zoning resolution, nowhere is there a definition of a fence. So if you don't know what a fence is, how can somebody put one up or take one down? And then 20-foot containers aren't defined at law. Once again, ordinances, statutes, resolution, they're not defined as structures. All right, so you have to ask yourself, okay, there are rules, there are regulations, and there are resolutions. The title of this is Resolutions Aren't Law, They're Policy. All right, now I know people don't like people on the videos reading things, but this needs to be read out because it's just far too much to memorize. Here we go. All right. I edited that out because for some magical reason these got swapped around and I couldn't find my place. All right. Here's a question on appeal. All right. Is a zoning resolution policy or the equivalent of a zoning ordinance, with the ordinance being of a general and permanent nature and having been enacted pursuant to the police powers of the state? What is the scope of authority of a zoning resolution? That being, against whom does it apply and under what circumstances, and whether or not engaging in business, commerce, trade, or industry, or subject to contract or license is a prerequisite for zoning resolution to adhere and be made enforceable pursuant to Colorado Revised Statutes 3028-124. I'll try to eliminate all the statutory references. All right, that's the question before the court on appeal. And here's the argument really close. Paraphrasing, all right? A county is not an independent governmental entity existing by reason of any inherent sovereign authority of its residents. Rather, it is a political subdivision of the state, existing only for the convenient administration of state government, created to carry out the will of the state. A county in Colorado is nothing more than an agency of the state in the general administration of the state policy, and its powers are solely governmental. As a political subdivision, a county and its commissioners possess only such powers as are expressly conferred upon them by the Constitution and statutes, and such incidental implied powers as are reasonably necessary to carry out such express powers, and it does not, unlike a municipal corporation, possess a complete local government of its own, executive, legislative, and judicial. Counties are therefore enjoined from enforcing, under the police powers of the state, any act not specifically authorized by statute or the Colorado Constitution, whether it be designated an ordinance, resolution, or regulation. In Colorado, adopting zoning ordinances is a legislative function entrusted to the boards of county commissioners. CRS 3028-112 requires public hearings before the adoption of any zoning resolutions, and since legislative acts don't require any such hearing, that procedural due process does not govern the enactment of legislation. It's plain that resolutions then are not legislative acts and therefore not law and not of a general and permanent nature. In fact, CRS 3028-111 is taken from CRS 106-210 from 1953 and 1963, where it is annotated, it's a case called General Outdoor Advertising versus Goodman. It states in pertinent part, on the face of the amended resolution, they're attacking a resolution here that was passed back in the day, it instantly appears that the county commissioners and the Board of Adjustments, without any set of standards or limitations, are permitted to act according to their particular liking for any reason or no reason at all. It would be difficult to find a more direct grant of arbitrary discretion and unlimited power than is here vested, and of course the freedom to use such power as it might relate to lawful enterprises and the use of property permits, uncontrolled regulation, and dictatorial powers of commercial and industrial enterprises in the area involved, and therefore is repugnant to the Constitution of the United States and that of the state of Colorado. The unlimited power therefore apparent is double-barreled in that it provides the power to grant and equal power to take away and destroy. In that case, General Outdoor Advertising, they struck down resolutions because they're dictatorial, right? Nobody has actually raised that argument that resolutions are not law. I've looked and looked and looked and looked and looked, and there's no cases that I can find that show that resolutions are not law, although it's clear that they're not law because they're not enacted. They're adopted, and there's a big difference between the two. Municipalities within Colorado have defined the difference between ordinances and resolutions. The Township of Meade, for example, states a municipal ordinance generally means that a municipal act is adopted that has the force and effect of law. That raises an issue. How does a resolution or regulation or rule have the effect of law if it's not law? You're bound to it. Why? Because of contract. You've gone to the county and you've filed a permit. You say, oh, I need a permit. You voluntarily stepped into their jurisdiction by filling out an application for a permit. So when the Board of Adjustments says no, the zoning department says no, then you have to take it up to the Board of Adjustments. You have to appeal. It's administrative law. Why is it? Because of contract. The question is that if you own your house, which we know we don't because the arguments from last time, but let's say that you own your house and you want to be able to put up a fence and you don't pull a permit, and then the county comes after you, and it's only a resolution now that they're charging you with, right? Says it's not law. It's never been law. It's what? Administrative law. You're bound to a contract to the county. For example, let's say you're a general contractor. What do you got? A license with the county. You got to follow the resolutions. You're a roofer. You're a plumber, electrician. If you're licensed within the county to conduct what? Business, commerce, trade, or industry. You're conducting business licensed by the county. What do you have a license? A license is permission granted by competent authority to do that which is otherwise illegal. So if you're a general contractor, you're a subdivider, you're a tradesman licensed in the county to do business, you have to follow the resolutions. Because those are what? An adhesion contract to your license. See how this all flows together? Yeah. Okay, a resolution is a formal expression of the opinion or will of an official municipal body adopted by a vote. A resolution may be a statement of policy by the municipal governing body, Board of Trustees, Board of County Commissioners, or an order of the municipal governing body that a specific action be taken. Fruita, F-R-U-I-T-A, Fruita, says an ordinance is a municipal law which may be amended or repealed by adoption of another ordinance. See the difference between the two? A resolution may be used to express city council policy, direct administrative or legal action, or to make a public statement from council. And Parker says all legislative enactments of a permanent nature shall be by ordinance. All other actions, except as provided in the chapter that they're referring to, may be in the form of resolutions or motions, right? And I'm not going to go on with all of this, but that's the point, is that what we have to understand is, what did I say before? Those adhesion contracts is where you lose your liberty, and in this case, your liberty is your right to be able to control your own real property. All right? So if they pass it by ordinance, it's a law, and then you'd have to follow it. But if that's not the case, if it's a resolution and you didn't put yourself into their jurisdiction by filling out an application and you're not licensed, you're not a licensed tradesman, and they're going after you for putting up a fence or a greenhouse or a chicken coop or anything like that, and you haven't pulled a permit, my position is that they lack that contractual nexus, and you have a valid argument. And this particular case, as it comes out of the Colorado Court of Appeals, and may or may not go up to the Colorado Supreme Court, depends on what the Court of Appeals says, that'll be another video after for that. There we go.